everybody. Happy Thursday, which means tomorrow's Friday. Very happy this week about that. It's been very, very cold. Okay, so what do we know now? I wanted just to talk to you about the immigration court hearings in New York and New Jersey. There's been a lot of confusion about that because since the court opened, there has been a lot of what we call our standing orders, which is an order issued by, in general, that should be applicable to all judges. The main issue that we have had is that even though there is a general order, a lot of judges would have their own rules, and because the immigration court is not known for picking up the phone, especially now in a time of COVID when there are severely understaffed and a lot of people, judges, clerks, are working remote, we would have to get individual instructions from judges on how they want hearings handled. There has been information distributed amongst the attorneys about what every judge wants. Some judges have been doing hearings exclusively remotely through what's called a WebEx. It's a type of platform just like Zoom or Google Meets and stuff like that. What happens most of the time with those judges is before the hearing, the attorney who is representing you is going to get a link to the hearing, and we just log in at the time of the hearing and conduct the hearing remotely, just like me talking to you right now. However, over the last several years, there have been judges who wanted to do things in person, right? So there have been judges who were asking for attorneys to come in person. So what has happened now? 2 days ago, there was a communication released from the Department of Justice that said that as of right now, through the end of January, due to the increase in COVID cases, all of the hearings, non-detained, unrepresented hearings, unrepresented meaning if you do not have an attorney, your case will be postponed. In terms of people who do have attorneys, right, their hearings are going forward, and they're going to be going forward remote only. Okay, so all of the hearings until at least the end of January will be remote. There are pluses and minuses to that. On the one hand, especially if it's a full individual hearing, it's unpleasant, I think, to sit for several hours covered in a mask, distanced in a small courtroom, rather small courtroom. It is much easier when you're remote because you don't have to cover your face, and you don't have to travel. It's cold outside. You don't have to use the public system. You can't be late for a hearing because it's remote. You can test out the program that it works before and just log in at the time of the hearing and do it. We never had any technical issues with the actual program itself, but you have to understand it's a hybrid program now, so we still submit all of the evidence and all of the documents to the judge by paper a lot of the times. The government attorney receives everything through an electronic system. They've been working with that system for about 5 years now. So everything that goes to the government, right, to our opponent, is filed electronically, but things that are going to the judge are now filed, with limited exceptions, still in paper. So if you are in court and the judge wants to see a paper that the judge doesn't have, you can approach the bench, approach the judge and show him a paper, show original, this and that and the other. When you're doing a WebEx hearing, of course, that's limited. Also, you see me like this, but let's say you're conducting a full-blown asylum hearing. The judge has to make a determination whether the judge believes the person and their testimony, and there's argument to be made that it's not the best or the easiest way to make a determination about a person being truthful or not through a video. But we live in a new era, and a lot of courts have been conducting hearings virtually. So this is going to stay. This doesn't seem to be going anywhere. Some people love it. I love it to an extent, especially for initial hearings when, it would take an hour and a half of wait, and the hearing itself would be rather quick. Nowadays, you can be sitting in your chair in your office, doing things, meeting with clients, and when the time of the hearing comes, you log in, you do a quick hearing, you log out, and you move on with your day. So like I said, there are pluses and minuses, but as of right now, if you do not have an attorney and you have a scheduled court date, and whether it's 26 Federal Plaza, 290 Broadway, or at Varick Street, because remember there are 3 immigration courts in New York right now, your case is going to be postponed. It's not going to be going forward. Okay, so that when it comes to immigration stuff. What we have been doing is, since our hands have been untied since the new administration took place, is that we, with a lot of these cases, for example, if you're married and you have a pending marriage-based application, under the previous administration, we did not have the ability to go to the judge and ask to terminate your case in order just to send it downstairs to USCIS in order for the process, to go faster, because of course there's a lot more freedom in terms of scheduling. There's a lot more, there's a lot less wait time when it's with USCIS rather than when it's with the judge. So, but before we didn't have this opportunity, whereas now we have many, many different cases pending before the judges where we've asked the judge to close it out and send down to USCIS. Theoretically, that is supposed to be a much faster way to go about things. Unfortunately, what we're seeing in reality is that it is taking quite some time for the immigration court to send the file down and for USCIS to receive, process, and schedule your interview. Some cases are moving faster, but we are seeing delay beyond what we would like to see. I'm going to put it this way for you. So if you have a court hearing coming up in the next month, that means we've already been in touch with you. We're already gathering your evidence and scheduling all of your preparations. In terms of, let's talk about work authorization. That comes up a lot. So there is no standalone work authorization in United States, and I did a whole episode on that. You can go back and look at it. So what does that mean? That means that if you're here and let's use the operative word undocumented, you do not have status in the US, there is nothing in it by itself that would give you work authorization. Work authorization is always in conjunction, is connected to another application. If you have applied for asylum, you will be eligible after a certain time for a work authorization. If you're married to a U.S. citizen, you would be eligible for work authorization under certain circumstances. If you filed as a widower, if you filed an abused case, if you're filing a SIJ case, if you're filing a cancellation of removal case, right? Those are all main applications that then allow you, if you've met certain criteria, to obtain a work authorization. Work authorization is not a right in this country, right? It is not something that is given out as far as right now is concerned. Okay, so there's also not a unanimous rule when it comes to work authorization. Whatever is your main application, let's take marriage-based case. If you have a marriage-based case, a green card pending on being married, on the basis of being married, or if you have a green card pending based on your child applying to you, it is depending where you are in the process, you can apply for work authorizations, and those, for example, cases do not have a separate filing fee for the work authorization. On a flip side, let's say you have applied for asylum, you have an asylum case pending. There are different types of criteria: waiting time, manner of entry, whether you've ever changed venue. All of these criteria have to be met for you to be eligible. Eligible is the main word for work authorization. And that category of work authorization has fees associated with it. That means government collects a fee in order to process that work authorization. Okay? So there is no, oh, he got it, I want it. That it doesn't work like that in reality. Each case is different. Your neighbor may have been eligible for work authorization under a pending asylum application because of the time when he filed, where he was in the process, right? Because remember, in 2020, the rules have changed. After that, some other rules have changed. After that, some independent, non-for-profit organizations have sued the Trump organization, and then there's some exceptions to the rule. It is not a straightforward, easy case, especially if you have asylum application. There's multiple now barriers to being able to be eligible for work authorization. Okay, so that's in terms of eligibility and processing fees. Some people are like, oh, this person didn't pay for work authorization, why am I paying for it? Because we don't determine the filing fees. The government has determined filing fees. There is a fee structure and we go by it. If you're in this category, we're going to tell you your filing fee is $85, $410, $495. Some categories have no filing fee. So that is what it comes to that. In terms of processing time for work authorization, we encourage you to apply for renewals 6 months before your current work authorization is expiring. We are seeing a trend. It has certain exceptions, but the trend is we're seeing is more than 6 months to get a new card, more than 6 months, right? Again, I know it seems weird because some work authorizations under some categories are only given for a year. So you got it, it's issued January 1st and it's supposed to expire December 31st, and then in June you have to already apply for it again. That is correct. You should apply 6 months before the current card has expired. There are very long delays, especially when it comes to certain categories with work authorization. There are exceptions. If you are working in the healthcare industry and you are an essential worker, there is a process by which we can request for the work authorization to be expedited, and we have done so successfully in the past. Okay? Rules are changing. They're changing all the time. There's new regulation, there's court action, and we're keeping track of all of that and complying with all of that. But I do want to tell you, there has been situations where we send an application out while the application is in transit, meaning we already mailed it out. There's a change in policy. By the time it arrives to USCIS, they want an additional fee. Or we've had a situation very recently when it came to work authorizations that were based on pending U visas, right? There was a big change in law this year that allowed all people who have prima facie U visa applications to apply for work authorization, and we had a bunch of those mailed, and we started seeing, we followed the fee schedule that the government, put out there, and we're mailing out those applications. Some of them were returning, telling us we have wrong fees, and we're like, we don't have wrong fees. We're putting in the fees that you, government, have been asking for. And lo and behold, several months after that, the USCIS has come out and said, yes, we have been making mistakes, and we have been taking fees where we were not supposed to, and we have been processing certain applications without fees. and we will try to make it right. Okay, so I promise you, it doesn't mean that we've made a mistake. A lot of the times, unfortunately, the U.S. government, the wheels of the government are slow. It's a huge machine, and they're processing a huge number of cases, and they do make mistakes. We've had wrong dates of birth, wrong pictures, lost money orders, wrong countries, misspellings on the on green cards and work authorizations, even though everything submitted, including passport documents, have had the proper name spelling in it. So those things have happened. There are fixable, so there's no reason to freak out. Just because your work authorization has a wrong or misspelled name, it doesn't mean it's not valid. You can still work with it while we're submitting a request to have a new one issued. So that is that. The very last thing I wanted to tell you, that for those people who are waiting for immigrant visas, I just wanted to tell you the backlog is 500,000 cases that are ready to have interviews scheduled but are hanging out in National Visa Center waiting for their turn. That's a huge amount. If you think about it, 500,000 cases that have been completed, and all they're waiting for is the interview, but they're waiting their turn. So please be patient. We're doing everything we can. If your case is eligible to be expedited, we're doing that. Unfortunately, there have been several cases that we had got a confirmation to have the case expedited, and expedited nowadays can mean 3 months of wait to get an interview. Yes, we've had a case, a father petitioning for a child, and the child having a condition, and we asked for the case to be expedited. They granted it to us in the fall, and then the interviews at the end of January. That's called expedited processing. 3 months was expedited processing. And those were weekly emails to the embassy, weekly emails. Finally, they've gotten our file from the abyss and decided to process it. So we're looking forward to that client coming here, hopefully sometime in February. All right. This is all for today. A lot of information. If you have anything, any questions and stuff like that, send us messages, email, text, phone number. As always, you can watch all of this on YouTube. You can contact us through any platform. We have WhatsApp, text message, phones, and emails, and so on and so forth. Skype, whatever your poison, we got it. I wish everybody a great end of the week. I'll see you next week. I hope everybody stays warm. Another 3 months of winter is coming. So thank you for watching, and we'll see you next week.